Hello, Colorado Realtors. Thank you for joining me for another edition of Legal Bites. I'm Scott Peterson. So this is the second edition in a row that we're going to be talking about a statutory change, another important thing impacting Colorado Realtors, and not just Colorado Realtors in this case, but a pretty wide variety of people, any covered entity, which is a very, very broad category as it's defined by a new statute that came through the legislative session between January and May of this year through the Colorado legislature, passed by the legislature, signed into enactment by the governor, by Governor Hickenlooper in May of this year, and it is effective this September 1st of 2018 is when this new law becomes effective. It was House Bill 1128, or House Bill 1128 was the name of the bill, and it has to do with consumer data security, or the protection of consumer data. And again, this has to do with not necessarily the wire fraud stuff that we've talked about a lot in the past, but this is the maintenance of any consumer data or personal identifying information. So just very quickly, who does it impact? It impacts covered entities, and covered entities is a broad definition. It's basically any public or private entity that has contact, maintains, stores, really even touches for their own records any personal identifying information, and that's the what that I want to talk about. Personal identifying information is anything, and it's literally defined as something as innocuous as a copy of a driver's license, certainly a copy of a check, an earnest money check, maybe. Obviously, credit card numbers, Social Security numbers, obviously, but a whole universe of documents that you might, as a realtor, come into contact with. Certainly, property managers could come into contact with through rental applications, Social Security numbers, maybe credit card numbers, that type of thing. But a realtor certainly could come into contact with and have reason to get a copy of or maintain a driver's license, a copy of a driver's license. Maybe it's an office policy that prior to doing showings with other unlicensed people or meeting somebody for a showing, that they require somebody to send a picture of their driver's license or a copy of their driver's license, something like that. Or, as I mentioned, an earnest money check, a copy of an earnest money check. Pretty broad universe of personal identifying information, and if you are a covered entity, which you are under the definition in the course of doing business as a realtor or as a licensee, you're a covered entity. So what this new law says is that if you have contact and maintain any of this stuff, you have to have in place a written policy that describes your mechanisms for the sanctity or security of that data. How are you going to keep it from being breached? And then if you go and destroy it, what are your policies for the destruction of that data as well? It's got to be a written policy. It's got to be kept in writing. So very important, because I'm guessing most brokerage firms and independent brokers or independent realtors don't actually keep that as part of their written policy. How are we going to maintain this data should we come into contact with it? And how are we going to destroy it or get rid of it if we need to get rid of it? There's also, as part of this new legislation, this sort of breach notification. And so to the extent that you become breached or this information becomes compromised in some way, you have to notify the parties whose information was breached of that breach immediately or as soon as reasonably possible, and in no event less than 30 days after that breach. So again, a really important piece of things for brokerage firms, independent brokers to be considering. I'm hopeful that the Division of Real Estate will put some rules in place related to what licensees or realtors need to do. Obviously, we could incorporate that, I think, very sensibly into the mandatory inclusions in an office policy manual, and that would satisfy the statute. So if it has to be in the office policy manual, then a licensee, by including that in their office policy manual, would satisfy the statute, potentially through some additional rulemaking and such. So I'm hopeful. Stay tuned over the course of the next 12 months or so as the Division of Real Estate and the Real Estate Commission kind of considers ways to make this a bit more of a turnkey solution, or to create more of a turnkey solution for licensees and obviously therefore realtors throughout the state to be compliant with this new statute. But in the meantime, effective September 1st of this year, any covered entity, and trust me, that is you folks, you guys doing business, you realtors, any covered entity has to have in place a written policy for dealing with this. If you are getting copies of driver's license or having copies of earnest money checks, anything even that innocuous would apply here. So do be mindful of this new statute. Again, if you have questions on this or anything else, you can always try and reach out to the Colorado Association of Realtors legal hotline. We love to hear from you guys. It's available from 9 to 12 and 1 to 4, Monday through Friday. Look forward to seeing you again on another edition of Legal Bites. Thank you very much.